My name is Oyebola. Today I'll be discussing interception of communications and its legal framework in Nigeria. Interception of information seems to pose a threat to the right of privacy of individuals. And privacy is paramount. It is paramount to individuals and it is guaranteed under Chapter 4 of the Constitution of the Federal Republic of Nigeria, 1999 as amended. In this discussion, I will examine interception of information, constitutional and all other legal framework that allows for interception in Nigeria. Under Chapter 4 of the Constitution of the Federal Republic of Nigeria, 1999 as amended, Section 37 guarantees the rights of Nigerians to both private and family life. The section stipulates that an individual has the right to privacy of his home, telephone conversation, and even telegraphic communication. This means that it is not only unlawful for government and even other citizens to invade the privacy of others, but it is a constitutional violation of the right guaranteed. This right guaranteed is, however, subject to the provision of Section 45 of the Constitution. Section 45 of the Constitution stipulates that the National Assembly can make any law as far as reasonably justifiable in the interest of public order, public safety, and even for the purpose of protecting the right and freedom of other persons. This simply means that the National Assembly can enact a law that will allow for interception of information in Nigeria. As it is, several laws have been enacted that allows for interception of information in Nigeria, and one of such is the Nigerian Communications Act 2003. This act is the principal legislation in telecommunications in Nigeria. The act stipulates that a communication service provider should use his best endeavor to prevent the network facility that he owns or provides from being used for the commission of an offense in Nigeria. The act also stipulates that the Nigerian Communications Commission, that is the NCC, can make a written request to a communication service provider that the communication service provider should assist as far as reasonably necessary in preventing the commission of an offense in Nigeria and in safeguarding national security. Also, under Section 147 of the Act, it stipulates that the NCC, that is the Nigerian Communications Commission, can make a determination to a communication service provider that the communication service provider should implement the capability that allows for interception of information in Nigeria. This simply means that under the Nigerian Communications Act, interception of information majorly occur to prevent the commission of an offense in Nigeria. It will also occur where an order is given by the Nigerian Communications Commission. There is also another act, which is the Cybercrime Act 2015. Under this act, unlawful interception of information is an offense and it is punishable under the act. Section 22 of the Act stipulates that the court of law can order a communication service provider to intercept information where such information to be intercepted is relevant in criminal proceedings or criminal trial. The court can also order a law enforcement officer to intercept information or record data for the purpose of criminal trial or criminal proceedings. There is another act, which is the Mutual Assistance in Criminal Matters Act 2019. This act, which was enacted to ensure the prosecution of criminal offenders, whether they are within or outside the country. Under this act, a foreign state can intercept telecommunications, postal items, electronic surveillances, and even computer data for the purpose of criminal investigation. This means that a foreign state where a mutual assistance in criminal matters agreement exists with Nigeria can make a written request to Nigeria to intercept information where such information is relevant in criminal trial or criminal proceedings. Also, motions with powers under Section 70 of the Nigerian Communications Act. The Nigerian Communications Commission has concluded plans to implement the lawful interception of information regulation. This regulation will specify the type of communication to be intercepted. This means that not just any communication can be intercepted by a communication service provider. The regulation will also provide the mode for the disclosure and collection of information. It will also specify a clear legal framework that allows for interception of information in Nigeria. Also, there is a bill pending in the National Assembly. This is the Telecommunications Facilities Law for Interception of Information Bill. This bill seeks to ensure that a communication service provider have the capability to allow national security agency and law enforcement officer to exercise their authority to intercept information without unreasonably impairing the right of privacy guaranteed under the Constitution or the provision of any law on telecommunications in Nigeria. It appears from my discussion that interception of information by government and even governmental agencies occur majorly to prevent the commission of an offence in Nigeria or even an attempt to commit the offence in Nigeria. It will also occur to safeguard national security, and it will occur where a court order is given and it is believed that the information to be intercepted is relevant in criminal proceedings or criminal trial. There is no doubt that collection of personal data by government and governmental agencies in Nigeria remain largely unsupervised. It is my opinion that Nigeria, in the process of safeguarding national security, should not lose sense of the rights of privacy guaranteed under the Constitution. Thank you. For more of this, you can visit our website at www.harlemsolicitors.com. Thank you.